You tell me.
Do you want to do? Do you want to do the Baltimore County ones or start with delegate legal?
Let's do the Baltimore County ones. Yeah. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, March 31st, 2026. Thank you for being here today. We've got a number of senators who are over in the House testifying on their own bills, just as our House members are here testifying for their bills. We're going to go kind of jump around a little bit and try to move people as quickly as possible so you can get back to your committee. So Delegate Ross, why don't you come up first and you can do the Baltimore County delegation bills. House Bill 305 is first and then House Bill 1529, if that works for you. We are having a mic problem. Okay.
Mic issue. Hi, yes, good afternoon, Mr. Chair. Madam Vice Chair and esteemed members of the committee, it is a pleasure to be here with you and thank you for the opportunity to talk to you about this bill. I am here requesting your support for House Bill 1529. This is a Baltimore County delegation bill. It passed in delegation and it also passed in the committee, Economic Matters, and passed, as you know, on the floor. So there's been a lot of support for this bill across the street, and I hope we can have that same success here. So the bill is about common ownership communities. Really quick primer. I'm sure you all know common ownership communities are HOAs, condo associations, and co-ops. And we have, in Maryland, we have over 1 million people who live in these communities. In Baltimore County, we have thousands of people who live in common ownership communities. And right now, these individuals are woefully under-supported, if not unsupported entirely, because there's just not an entity in Baltimore County to support their very unique needs. So this bill creates a framework for a commission to support people who live in common ownership communities. It is a supportive body that will give them resources. It will help them know whenever there's a new bill that will affect how they operate, that they are required by law to follow. We have many communities who never even know they're not in compliance. So this commission will help them to stay in compliance. It is not a regulatory body. This is not an ombudsman's office. If you saw anything to that effect, that is not what this bill is. It's just a framework to establish a commission. Think aging commission in Baltimore County. Think the Veterans Commission. They are not regulatory bodies. They're there to be a resource for the people, those specific people who are affected by those issues. That's what this is. So this bill, and I said it in delegation, I'll say it here for total clarity, this bill is the framework, so it does not mandate Baltimore County to establish the commission. It will establish a framework for them to follow. So it's like a franchise. So you get to decide if you want to purchase a franchise, but if you do, it needs to follow the framework of the corporate office. So you can decide if you want to purchase a McDonald's, but you don't get to decide what the French fries look like, or if you're going to do burgers or fries. That's what this bill is. This is the framework for this franchise in that analogy. So one important thing that I want to highlight about this bill is that HOAs in particular are well positioned to help the economy of Baltimore County. These communities are governed by many governments. They exercise great authority, the individuals who serve on these boards, to be able to levy assessments. They can raise those assessments. They can place a lien on your house. They can foreclose on that lien. They have great authority over the people who live in those communities. And many of them do not have the requisite training or support to be able to do that job fully. So we've heard from board members as well as the homeowners who live in those communities, aside from those serving on the boards, that they want this support, that they don't have it. They want to do the best job possible, and they need a body commission to help them to be able to do that. But these communities, HOAs in particular, typically have higher property values. High property values are intrinsically linked to a robust local economy, as we all know. These associations can boost local economies through well-maintained neighborhoods. Home property values significantly will affect Baltimore County's tax base, which directly funds our local services, our roads, our public safety. So we all want to see these communities do well. This is a great way for us to help the economy in Baltimore County. We just had a briefing just a couple days ago from the Economic and Workforce Development Director, who let us know that we have seen some declining population in our county. So we want to continue, we want to bring people back, and the best way to do that is to have these very well-run communities, well-maintained communities with large budgets, many of them, to manage the communities, and we want to see them do well. So this commission will help those communities continue to run well and drive people into our county and boost our tax base. So it's important. There's precedence for this. Montgomery County and Prince George's County already have these commissions in place. They testified at the delegation hearing, and they talked about the outcomes they've seen, the participation from the communities, the level of support, how lawsuits have gone down because people aren't suing the HOA, or the HOA is not having to take people to court because these things are getting resolved outside of court. So lots of benefit all around. And lastly, I want to point out that the version you may have, I hope that you do have the amendments on this bill. Originally, there was a dispute resolution process that was outlined. That was taken out of the bill. So this bill is not mandating that Baltimore County follow a specific dispute resolution process. It just requires that they have something in place. So they're not restricted to what you may have seen in the original version of the bill. There's also no fee that this bill is calling for. Originally, there was they may include some sort of fee to offset the cost. That's not in this bill. So I just want to clarify that based on the version that you have in front of you. This is a supportive commission. We got a very, very low fiscal note from the county on this, widely supported. It would be up to them to decide if they want to do it. We're just giving them the framework to make sure that it's successful when and if they do. Again, Delegate Kim Ross here asking for your support for House Bill 1529. I am more than happy to answer any questions you might have.
Thank you, Delegate Ross. Any questions for this local bill with no opposition? All right.
Thank you.
Seeing no question, Delegate Ross. We also have you as for House Bill 305. Would you be willing to present House Bill 305, or will another member of the delegation be presenting this?
Another member of the delegation will present that bill.
Okay,
it's actually, not on my list to do that today.
Okay, we don't do politics here, but I will know that Delegate Ross has the coolest logo, campaign logo, and coolest colors. If you want to check it out, it's really cool.
I appreciate that.
Thank you, Delegate Ross.
Thank you very much.
Next, we'll move to Delegate Weigel, I saw with House Bill 1362.
Good afternoon, Chair Wall Stryker and members of the Judicial Proceedings. I'm Delegate Weigel, pleased to present House Bill 1362. The legislation simply requires that meetings of the Council of Unit Owners, Board of Directors, or governing body of a condo and of a homeowners association be recorded by video with audio or by audio only. The version before you passed the committee on a unanimous vote. That was Economic Matters, and it passed the House floor on a vote of 133-0. It includes amendments that reconcile concerns of interested parties, including clarification that the requirements do not apply to developers, prohibition of the meeting being recorded if a member objects, and prohibition of meetings being used in place of minutes. Concern was also raised by an interested party in Economic Matters regarding the legislation potentially violating wiretap laws. So I did obtain an opinion from the AG's office that states that the legislation does not violate provisions of that act, and in summary, that communications at an open meeting of a condo or HOA governing body do not constitute private conversations, and recordings of such meetings would not violate the act. Adopting the provisions of this legislation would promote transparency and accountability, ensure accuracy of minutes, provide increased accessibility for homeowners, reduce conflicts and disputes, and strengthen homeowner engagement, all at a minimal cost and administrative burden. All of you are fully aware technology today allows meetings to be recorded by the press of a button, and all participants are automatically notified when utilizing video conference platforms for virtual meetings such as Zoom or Teams. And in-person meetings can be recorded by the press of a button. I'll keep it short. I thank you for your attentiveness, and I ask for a favorable report on House Bill 1362.
Thank you, Delegate Weigel. Any questions for Delegate Weigel about this legislation? All right, seeing no questions, we thank you very much. That concludes the hearing for House Bill 1362. Delegate Smith is joining us as well. Here's the order in which I saw people. Delegate Smith, and then Delegate Schindler, and then Delegate Embry will be our next few bills here.
Thank you, Mr. Chair and distinguished members of the committee. For the record, I'm Delegate Stephanie Smith, here to present House Bill 503. This is a simple bill that closes a technical loophole regarding statute to make it clear that during collective bargaining negotiations, members of the Baltimore City Sheriff's Office, FOP Lodge 22, may bargain for salary, wages, and merit step increases. While this may seem obvious, the current statutory language creates ambiguity. As a result, the parties have been forced to engage in a workaround process during negotiations that is confusing and inefficient for everyone involved. This bill simply clarifies the legislative intent. It ensures that the compensation elements typically negotiated in collective bargaining agreements are clearly authorized under the law. It does not create new categories of bargaining. It aligns statute with practices and eliminates unnecessary procedural complications. The Fraternal Order of Police Lodge 22, the Baltimore City Sheriff's Office, and the Mayor's Office are all in support of this bill, and you do have testimony to that effect, and they're also in the audience should anyone need to ask any additional questions. This is a collaborative measure with agreement among labor, management, and the city. And with that, I respectfully request a favorable report for House Bill 503.
Thank you, Delegate Smith.
Thank you.
Very efficient. Any questions for Delegate Smith regarding this bill? All right, seeing no questions, that concludes the hearing for House Bill 503. Thank you for joining us today. We'll now go to Delegate Schindler. It's the Redhead Convention here today.
Thank you, Mr. Chair, Mr. Vice Chair, honorable members of the committee. For the record, I'm Delegate Matthew J. Schindler, and I'm here in support of House Bill 172. This bill was passed through the House with a favorable record of 124-1 and is an MML priority and supported by Baltimore City and many other municipalities. HB 172 is simply an enabling legislation. Would allow municipalities to authorize enforcement officers to wear body cameras if they choose. This legislation would allow municipalities to enhance transparency and ensure that enforcement officers and constituents are able to access a record of their encounters. In my previous experience as a member of a local city council, I witnessed many complaints and issues regarding code enforcement that could have been readily resolved if there was a digital record of the enforcement encounter. I believe this legislation would also create a tool that can boost government trust, efficiency, and transparency. Body-worn cameras also act as a deterrent toward potential aggressive or confrontational interactions, providing safety for both officers and citizens. This bill carries no fiscal note and merely just gives local jurisdictions another tool for their toolkit. With that, I thank you all for your time and respectfully urge the committee for a favorable report on HB 172.
Seeing no questions, thank you very much.
Thank you.
All right. Delegate Embry, House Bill 1441 and 1348, whichever one you would like to choose.
May I start with 1441? Thank you, I appreciate it. And it's nice to be back again. Elizabeth Embry, District 43A. So House Bill 1441 is a bill that I brought at the request of the district court. So currently there's 2 citations relating to public consumption of alcohol and open container that are not prepayable. For reasons that I don't fully understand, and maybe some of you who are here when it passed will know, but we don't know. And it's a problem for everybody. It's a problem for the person who has to take off work, so they have to come to court. It's a problem for the police officer who has to come to court. It's a problem for the court has to staff the court. So there's no opposition. It would just like any other citation, it would be prepayable in the same way. People could still request a trial, but it would allow everyone involved, if they wanted, to avoid the court date. So with that, I will stop talking and would love to answer questions.
All right, seeing no questions.
Terrific. All right. The next bill is House Bill 1348, and this relates to human trafficking. So we created a system of regional navigators across the state, and they now serve every jurisdiction, and they support victims of trafficking, labor and sex trafficking in countless ways, providing support, connecting them to resources. This bill does two things. One, it explicitly allows mandated reporters, like a teacher or police officer, et cetera, who comes across a victim and who has to report it, it would allow them to contact the regional navigator if they think that by doing so they can help the victim. So right now, that's not in law. This just creates a streamlined process for them to do that. They can do it without the victim's consent if they believe not to do it would cause serious harm to the victim. But again, all the regional navigators do is provide support and resources. The second thing it does, it allows, explicitly provides for the the Attorney General's office to prosecute sex trafficking, just as it does labor trafficking. They do it already. They do it currently pursuant to governor's letters and referrals from state's attorneys, but this would make it consistent with what we've already provided in law for labor trafficking. There was no opposition, and there is not a fiscal note. So I would welcome your questions and welcome your support.
Seeing no questions, thank you very much.
Thank you. Appreciate it.
Thank you. Next, we're going to call Delegate Allen. I guess 645. And by any chance, are you here for the 30? No, never mind. Go right on in.
Just this one, Mr. Chair.
This one. Thank you.
All right, members of the committee. My name is Delegate Nick Allen. I'm here today to testify in support of my bill, House Bill 645, Criminal Law, Assisted Reproductive Treatment. You may have seen some of the news stories or possibly documentaries on television about people who've taken at-home DNA tests like 23andMe, and when they get the results back, their lives are turned upside down forever. Instead of merely learning a little bit more about their genetic heritage, they discover a secret, and they in fact have dozens, if not hundreds, of half-siblings that they never knew about. In many of these cases, the biological father of all of these half-siblings was actually a physician who provided assisted reproductive treatment to their mothers decades prior, but instead of using the sperm from the intended father or sperm donor, that doctor used his own sperm without the knowledge or consent of the patients. The sad truth is this has happened in multiple cases with multiple physicians doing this in multiple states. And in each case, it's literally hundreds of lives affected. Those are the parents and patients, their families, and their children. This specific type of fraud is so beyond the pale for many, many reasons, but it also creates so many ripple effects which go on for generations. Imagine if you found yourself in this position. So over the past decade, since the advent of these at-home DNA tests, states are taking steps to address this type of fraud. So that's what House Bill 645 seeks to do in several important ways. First of all, it makes it clear that anyone who does this commits a felony, which I think is important to define. According to a letter we received last year from the Office of the Attorney General regarding last year's version of this bill, under current law, criminal liability for this type of fraud is, quote, very limited. There could be prosecution under some form of second-degree assault, but that conviction will be difficult to attain, especially if the crime occurred long ago and evidence is sparse. So by making this type of fraud explicitly a felony, we close any potential gaps in criminal code. The other aspect of this bill include giving civil standing to not only the patient victim, in these cases the person who gave birth following the fraudulent assisted reproductive treatment, but also to their spouse or partner and the child who was born as a result. This part of the bill may seem broad, but I believe it's very important because in most of these cases, this fraud is only uncovered decades later after someone takes an at-home DNA test. So again, according to the Office of the Attorney General, under current Maryland law, anyone besides the patient victim themselves would have an immensely difficult time asserting any civil claims whatsoever, especially, again, if this misconduct was decades prior. Given that the chances of success for a civil claim are slim and criminal prosecution is very unlikely, under current Maryland law, very few remedies exist. As in most states without specific laws to address this, the only remedy is to settle with the physician, typically out of court, and typically with a non-disclosure agreement. What this amounts to, shockingly, is allowing fraudster physicians to continue practicing, and we know this has happened, and this is absolutely unacceptable. I know from personal experience that the process of going through any form of assisted reproductive treatment is incredibly emotionally difficult for any family, full of hope and disappointment. And I simply cannot imagine going through all that just to find out decades later that my family had been defrauded and violated in ways such as this. So let's help protect Maryland families and patients, and for those who have been deceived in this way, let's give them the tools to help fight for justice. I respectfully ask for a favorable report, and I look forward to answering any questions you may have.
Thank you very much. Senator James.
Hi. Thank you for bringing this bill. I do remember seeing some news articles, so you may not know the answer, but I'm just asking, is there a pattern or theme to why these, particularly doctors are doing this? I mean,
There's,
is there something that, is there a through line there at all?
in some cases, it's honestly, it might be a religious thing. They might believe it's, part of their duty to, reproduce as much as possible. In some cases, they think just their own genetics are really, really good, and they want to share it with as many people as possible. There's examples.
So there's narcissism in either one of those, lack of
There's a man in Europe who's estimated to have possibly donated 1,000 times.
It's like Genghis Khan, right? I think a lot of us have his DNA, but no kidding. But what I'm trying to figure, the families that go, and thank God we have this wonderful thing so that people can go this route. So they come in, is it usually the husband, I guess, that because the way the physician would get himself into this situation is that you're looking for donated sperm, right? So is it that he's replacing the husband's sperm, or is it, or are they selecting a sperm donor, but he says, you know what, hooey on that guy, I'm better than that, and goes ahead and, is it both? Or
It could be either case.
Do you see, is there more of one than the other, or?
I think the phenomenon that, again, at least the one that grabs a lot of the headlines is when it's the doctor himself.
Right.
But I mean, there's also cases, again, of people donating in ways that are inconsistent. Like every sperm bank has its own rules about how many times someone can donate, how many times they use, that donation. So it kind of varies. So what we did in drafting the bill, and there's similar legislation in several states now. I think there's up to 11 or 12 states. The goal is making sure that everything, regardless of whose reproductive material is being used, whatever it is, it's being done that's consistent with the consent that's been given by the patients.
Right, and I guess sort of I have one last,
Of course.
Now, like you said, many of these people don't even question this, so not decades later, when you do an Ancestry.com or something like that, are we in a better position today to ward off this kind of behavior? Are there better mechanisms than there were back in the day? Does, may not even been easily accessible at Ancestry.com, or do you think this problem is still growing or still persistent? And then that's the last of my questions there.
I honestly don't. No, I would think we're in a better position than ever. Commercially available at-home DNA tests are, again, cheaper and more available than ever, and I think that's overall a good thing.
Right.
But the fact that it happened, as many times as at least we know about, I can only guess how many times it's happened.
The only reason I was asking was this is after the fact. And
right.
Honestly, you can't put this genie back in the bottle, right?
Right.
And it's a life-changing thing, as you say. So thinking of, I don't know, we can talk later offline, but about trying to prospectively see how we can maybe take some further action to tamp down it to begin with. For example, maybe requiring that DNA tests be taken quite early in the process so that people make an informed decision about whether they want to continue with this or not. And it also, that early clampdown might then dissuade the narcissistic doctors and whatnot and others from going forward. Would you be amenable to something like that?
Yeah, for sure. And I know I said last year, because the original version of this bill last year was actually in the since departed HGO committee. And I said there, that committee and I think the Maryland General Assembly in general has done a lot of work over the last decade or so to really increase access to fertility treatment.
Yes.
But if we're going to increase access, we should also make sure that access is safe.
Thank you, Mr. Thank you.
I think I had a few questions. Looking at page 2, lines 12 through 13, where the felony is created, I'm curious if this penalty is comparable to the assault that you had mentioned. I think, did you say second degree? Or
I believe so. I cannot remember exactly, Senator, the drafter's rationale for it, but I believe it was comparable roughly to second degree assault.
All right. And I understand the woman, I'm understanding the nexus between the spouse of the woman who gives birth, but could you help me to understand why the child born, why they're included?
Because in a lot of these cases, especially in recent years, the parents have passed on. The parents have passed on because, again, this has taken, years later. I mean, people are in their 40s, 50s, or 60s when they're taking the at-home DNA test. So that's when they first gain knowledge about this. And, we felt like making sure the child is, that's born and honestly, with different genetics than they ever realized, if they're more susceptible to certain diseases that are carried, or I think the mentality was to give them some standing there as well.
And with regards to the what I look at as the statute of limitations on page 3. Could you explain the 10 years and the 20 years?
So again, the goal here is to kind of give a few different windows, again, because this tends to be uncovered so long after the crime has taken place. So that's why we included the 10 years, the 20 years after the reproductive treatment, and then the 2 years after the DNA analysis. I felt the DNA analysis portion was important as well.
But the trigger for these things are usually the person taking the DNA test, right?
Yes.
So that's when they would likely come into knowledge. And if this were a crime under current law, you'd have 3 years from the date that you took that test and you had knowledge. So I'm trying to understand. Maybe I'm misunderstanding, but is Roman 1, it gives you 10 years to file after the child is born as a result of the assisted reproductive?
Right. If you find out through means other than a DNA test, if someone else if there's other cases of it or something like that.
Right. Okay. Thank you.
Of course.
And seeing that there are no other questions.
I think we've got one more.
Sorry, Senator.
Thank you very much. There's one question. I know that statute of limitations 10, 20. To your knowledge, what is the age of the oldest person that found that out?
That's a good question. I think most of these, most of the things, the occurrences of these, at least the high-profile ones, occurred in the 1970s. I think that's really when IVF kind of, came about in or any form of assisted reproductive treatment kind of came about in a, more available way. So I think probably in the late 40s, early 50s is probably the
And why is the
age.
statute of limitations at 20 instead of, well, I guess that's all you can do. You can't do 30, you can't do.
Right. If they
Gotcha.
again, if their parents have passed by then,
right.
yeah.
Thank you very much. Good bill.
Thank you.
All right, thank you very much. That ends
Sure.
your bill hearing. Next, I believe, did she leave?
Yeah.
Is anyone here for House Bill 1116, a Howard County delegation bill? All right, wonderful.
Thank you very much. For the record, I'm Delegate Natalie Ziegler here with House Bill 1116, illegal dumping in Howard County. So this local bill had a very fun creation story. My interns set up a pitch competition, kind of a Shark Tank type thing, to try and come up with an idea of what to do about the horrendous illegal dumping problem in Howard County. I don't know if you saw the Washington Post this morning, but apparently it's a statewide problem. They spent over $16 million in 2025 picking up trash and took 5 million pounds of litter off the streets. It also gets chopped up when they mow the sides of the highways and turns into little tiny pieces that animals eat that get into the water, end up in the Chesapeake Bay. It's a health hazard, it's dangerous, it's ugly, and it's really hard to catch people doing it. So we worked with the State Highway Administration. Even though we had this pitch competition, realistically, we ended up doing something not very creative. We just added ourselves into Baltimore City's already very effective program. So this is a pilot. It's a 5-year pilot that would allow SHA to set up cameras at hotspots that they will pick and give permission for to try and catch some of the worst offenders. And the Howard County Police Department was delighted to provide the cameras and will issue the citations. And our hope is that we will not only recoup some of the money that we spend picking up the craziest trash, boats, biohazards, people just dump unbelievable stuff, but that we will also deter it. So I respectfully ask for a favorable report.
Thank you very much. Seeing that there are no questions, that ends our bill hearing on HB 1116. Delegate Tomlinson?
Thank you.
Did you come in? So this is HB 1520.
Thank you, Mr. Chair. Honorable members of the Senate Judicial Proceedings Committee, for the record, my name is Delegate Chris Tomlinson. I'm testifying on House Bill 1520. This bill updates Maryland's exemption laws, which determine what property and money folks are allowed to keep when facing debt collection or bankruptcy. Many current limits are outdated and no longer reflect today's cost of living. This bill helps working families, seniors, disabled Marylanders, and veterans avoid financial collapse while still holding people accountable for legitimate debts. It aims to give consumer debtors a new beginning so they can remain productive, contributing members of society. Such legislation protects basic household property up to $5,000 as compared to $1,000. This allows individuals to protect everyday necessities such as clothing, furniture, appliances, books, and pets, ensuring that families do not lose basic household items over modest debts. This bill protects up to $10,000 of equity in a motor vehicle, recognizing that cars are essential for work, school, and childcare. The current amount of equity protected is $6,000. For elderly or disabled individuals or households, the protection increases to $25,000 under this bill. Vehicles modified for disabilities, such as wheelchair lifts or hand controls, may receive additional protection. Under this legislation, disabled veterans receive an additional $10,000 cash exemption, recognizing service-related disabilities and limited income. The bill automatically protects $500 in bank accounts at each financial institution so folks can pay for rent, utilities, and groceries. It reduces unnecessary account freezes and provides clarity for banks and courts. The legislation also allows individuals to protect up to $6,000 in cash or personal property, giving families flexibility to cover urgent expenses. And the bill protects qualified retirement accounts such as 401ks and IRAs, so individuals are not forced to drain retirement savings and rely on public assistance. The bill does not allow people to avoid their debts. It ensures that Marylanders can keep basic tools they need to work, live, and recover from financial hardship. It updates dated limits, protects seniors, disabled residents, and veterans, and helps prevent homelessness and increased reliance on public assistance. The legislation has the support of Maryland Legal Aid, the National Association of Consumer Bankruptcy Attorneys, and the Attorney General's office. The AG's office, they're not able to be here today to provide oral testimony, but I'd like to read just a brief excerpt from their written testimony. Consumer debt collectors often purchase charged off consumer debt for a fraction of the face amount and then sue to collect the full amount. These actions frequently go to judgment without a hearing, without proof that the debt is owed, and without a meaningful opportunity for consumers to contest the validity of these debts. Consumers may face default judgments against them due to the lack of notice, being unable to take time off for work or take time off of work, language barriers arising from age or lack of sophistication, or the inability to obtain or afford an attorney. Increased exemptions protect consumers by allowing them to maintain their basic needs after judgment, particularly if the judgment was obtained unfairly. It's also important to note that this bill passed unanimously out of the House, and with that, I look forward to a favorable report on House Bill 1520. Thank you, Mr. Chair and honorable members of JPR. Thanks.
Before we go to questions, we'll let your witness testify.
Hello, my name is William Steinwhittle. I'm the Deputy Advocacy Director for Homeownership Preservation at the Maryland Legal Aid Bureau, and I testify in strong support of House Bill 1520. One of the most important provisions of House Bill 1520 from my perspective is the exemption of the child tax credit and the earned income tax credit. At Maryland Legal Aid, we have seen hundreds of people come through where a bankruptcy would be helpful as their wages are being garnished and they are low income. However, they have received a earned income tax credit that they desperately need to pay rent and utilities, and they are unable to file bankruptcy because of the risk that that asset may be at stake. And it is important to know that earned income tax credit was an outgrowth of the 1996 welfare reform bill, and it is not an asset, it is income. It is reflective of a person who is low income, who receives a credit because they are working the most that they can to usually support several family members. In addition, we are in strong support of the car exemption. Used car values are going up exponentially in Maryland currently right now. And it is almost impossible for low-income homeowners and low-income debtors to buy a car. But without having the ability to get a car, they can't go to work to satisfy their debts and also to pay their rent and pay their utilities. So we believe that this car exemption is very important to the long-term growth, economic growth in Maryland. Finally, Maryland is way behind the national trend in regards to exemptions. We have an overall grade of D from the National Consumer Law Center for exemptions and F for protection of the home, which is not an issue in this bill, but is still, we do not protect nearly as many assets as our neighboring states and our fellow states. So for those reasons, Maryland Legal Aid testifies in strong support of House Bill 1520. Thank you.
Thank you very much, Senator James.
Thank you, Delegate, for bringing this good bill. It's good to see you, and I like working with you. But I was curious about this issue, and not to try to have you rewrite the bill, but it seems to me it might even be smarter prospectively, maybe next year, to put like an inflation index connector here so that people don't have to wait for a good legislator to pick up a very important problem. Like car values that just, or particularly real estate, because that we do know. I don't think it rarely ever goes backwards, but just something to think about, because it does seem to me that this is a long overdue problem, and we ought to be, I just think Maryland should stay really on top of it and perhaps not be reliant on good legislators to see this, but perhaps have some kind of modest increases, certainly if, like with cars, as we're seeing now, it's going up exponentially, and housing too, we could certainly then add to it. But just a thought, did you look into that? And because you did pick amounts in here, and I don't know if you want to explain those amounts, whether you looked at what it would have been had we had a consumer price index all along. I don't know where you came up with the amounts that you decided to increase them to, if you use some kind of logic and math formula, but to me, going forward, that might be something. So 2 questions. How'd you come up with the numbers? 2, would you be interested perhaps in let's thinking about a bill that might make some of this automatic in terms of some increases?
Yeah, thank you for the question. You bring up a good point of maybe looking at it from that perspective of, of having some kind of index where it automatically just kind of happens because, for instance, the one where we're increasing or trying to increase the exemption for household goods from the current level of 1,000 to 5,000. The last time that was updated was in 2004, so over 20 years ago.
Right, exactly.
So unless there's a legislator coming before this committee, then otherwise it just remains as such.
Right.
Are you familiar with any other states that are doing what she's proposing?
Yes, some states do.
Do
You want to stand up for a second? We have, thank you.
Some states do attach their exemptions to a consumer price index. I believe California does, and some other states do as well. So
it does make I think it might make some sense. The other question, either one of you, the increases that you chose, did you do that by trying to guesstimate what it would have been if we had a consumer price index all along, which would, or if inflation, at 2 or 3%, Or just how did you get the numbers that you're now increasing to? That's what I was asking. That's the second question.
So I think the numbers that we came up with were comparative to other states. I believe DC has a $20,000 thereabouts car exemption. So we thought something in that range
Right.
Was what we were going for. Also, you know, we thought, you know, $1,000, you know, usually they do them in whole numbers. So we thought 5,000 would be the next one that would make logical
Because, you know,
sense.
regionally, that's another thing to be sensitive to, that regionally around here, houses, cars, well, not so much housing, is very regionally subject to different pricing than it would be, let's say, you know, in a rural area of Kansas. So that would be an area where we would have to pay a lot of attention, even if we put a cost of, you know, some kind of automatic cost in there. Well, thank you both very much.
Thank you. I just had a question. The testimony that was from the Attorney General's Office Consumer Protection Division, it's testimony that was noted over at the House, where it said it's supported in concept, but some of the things that it addressed, I'm curious, are the modifications the amendments that were made to this bill based off of these?
Yes, yes, I worked very closely with the Attorney General's office to get the amendments to exactly what they were looking for.
Thank you very much.
You're welcome.
Senator James, are you good?
Oh, I'm sorry, yes. Turn my little,
Okay, very good. Thank you very much. We do have one person in opposition, Mr. Enton, of course.
Of course. You know me too well. Thank you very much. Robert Enton on behalf of the Maryland Bankers Association. And I have had a meeting with the sponsor to talk about maybe see if there was something we could work out. But, you know, banks are creditors. Banks lend money. They lend it to businesses. They lend it to consumers. Businesses, what this bill applies to, and if they don't get paid, and they have really no choice but to go ahead and sue and get a judgment. But, you know, for your constituents that are businesses, when they don't get paid, whether they're a plumber, an electrician, a small grocery store, a pet shop, you name it, what choice do they have when they don't get paid? They furnish the goods, they furnish the services, and now they haven't been paid. So what do? They go to the district court, probably, the lower court. They file a lawsuit. Maybe they have to hire a lawyer, and they get a judgment. But then how do they get paid on that judgment? Just because you have a judgment doesn't mean somebody's in contempt of court if they don't pay you. So you have a couple choices. You know, you can try to attach a bank account. We've had those bills in here. You can try to attach their wages, garnish their wages, or you can let the judgment sit there. You record it in the circuit court. Maybe if a house gets sold, you get paid. But to come in now and go from an exemption that exists of $1,000, increase it by 500% to $5,000, and then depending on your age, and look, I'll qualify for the increased amount, to base it on your age, that now I'm going to go from $1,000 to $10,000, okay, 1,000% increase. And if I have a car, you're not going to be able to get to my car, even if I'm driving a Cadillac or a Rolls Royce or whatever, Jaguar, and if the car's worth $60,000 or $70,000 and it's free and clear, I can't go get that car. It's limited to what I can get. So it just seems to me, from a matter of fairness, you're dramatically limiting the rights of creditors, and that's, I think, problematic. Just to finish up, I see you're ready to shut me down, Mr. Chairman. Just to finish up, to say that I have committed to meet with the sponsor and see if we can work out a compromise.
Thank you very much. Senator?
good to see you. It's sort of that's why I was asking the bill's sponsor, where did these numbers come from? Because I think you would not disagree that a number that was in a statute that was created 21 years ago might need some adjustment, but you would need I agree. I think there should be a logical connection to bearing in mind inflation and whatnot, because the policies, we do allow some exemption. So where I think we're on the same page, which is we have to come up with a logical, reasonable increase, and perhaps that's where you're going to.
Yeah, and I wouldn't have a problem with that,
Okay.
Senator. I mean,
Right.
look, we come down here, the bills get put in, sometimes they pass, sometimes they don't pass, the years go on. I mean, right now, inflation over the last, 10 years has been somewhere between 1%, and maybe it got as high as 4 or 5%, but just for a short period of time. And does that mean that every year you come in and adjust one of these dollar amounts in a statute to account for inflation? Typically, that doesn't happen. I'm not sure. We've seen other bills in this committee, particularly like in the non-economic damage cap. Put in, if you go back, I'd have to go back to when it was increased to 1,000. I don't know when.
Right.
And then if I add in the cost of living, from then, I'm not sure what number I come up with. Would it go from 1,000 to 10,000? Probably not.
I agree with you. I think we're on the same page that there ought to be some connection.
Yeah, I wouldn't have a problem with that. If there's a bill that does that, if it's tied to the cost of living, maybe it's something, we could all get behind and support. But I do have concerns just about these arbitrary number increases in this bill.
All right, thank you.
Thank you very much. And seeing there are no other questions, that will end our hearing.
Thank you.
All right. Is anyone here for House Bill 305?
I am.
Oh, I know you are. No, we don't know. We don't do that yet. 1222? 1467? All right, House Bill 336.
Good afternoon, Chair Sidnor, Vice Chair, and distinguished members of the committee. For the record, my name is Delegate Jackie T. Addison, and it is my pleasure to submit testimony in support of House Bill 336. House Bill 336 is legislation that aims to improve the criminal justice system by preventing district court commissioners from issuing arrest warrants based on only one person's statement, whether that person is the alleged victim or the defendant. Police and or the state's attorney needs to be involved. True probable cause of arrest shall be the stepping stone of our criminal justice system, not an unverified statement. Currently, the law allows a district court commissioner to issue warrants based solely on a private complaint with a thorough investigation of allegations. Because of this, an innocent person may be arrested and subject to penalties based on a single statement, incomplete information, or malicious complaint, which is a complete misuse of the commissioner system. House Bill 336 makes a positive change by allowing district court commissioners to issue summonses for appropriate offenses while requiring review by the state's attorney and judicial approval before an arrest warrant is issued when warranted. This legislation also strengthens penalties for false statements. As outlined in the bill, making a false statement can result in a prison sentence of 6 months. False accusations have serious, long-lasting consequences, not only for the individual involved, but also for public confidence in our criminal justice system. For the record, this bill does not limit a victim's ability to seek justice. It is not a domestic violence bill. I repeat, it is not a domestic violence bill. Rather, it is a bipartisan measure that has been under extensive development for approximately 3 years. It is due process legislation that seeks to ensure that arrest warrants are used responsibly and fairly. I have seen firsthand that the damages that the false allegations can do to our justice system. And for this, I urge a favorable report on House Bill 336 and include in this hearing record. Thank you for your time and consideration of this legislation. And I'd like to say that in the House, it passed 125 to 10.
Thank you very much.
You're
Whichever
welcome.
one of your witnesses like to go next.
Thank you. Good afternoon, Chair, Ms. Sidnor, and ladies and gentlemen of the committee. My name is Ivan Bates. I'm the current State's Attorney of Baltimore City, also currently the President of Maryland State's Attorneys Association. I'm also joined today by Assistant State's Attorney Stephanie Bryant, who's a supervisor and oversees the domestic violence court that we call Part 5 at Eastside Courthouse in Baltimore City. She's very well versed and deals with a number of these issues that House Bill 336 presents on a daily basis. We've been working on this for about 3 years since I've been state's attorney. However, this is something I saw a long time ago before I was a state's attorney. I was a criminal defense attorney. One of the issues I always had was that I had clients who are locked up, they were arrested, they sat in jail for 30 days, and then their cases were dismissed. There were constantly warrants being put out for them. I have to thank Delegate Jackie Addison for the work that she's done with this, but one of the things I wanted to do, I wanted to look at the data. What is the data showing in reference to these issues, and are these issues in Baltimore City? In 2025, there were approximately 290 total cases that individuals received in terms of going to the court commissioner. Of that 290, 112 of them were issued warrants for the person's arrest. That means 178 were summons. Of that, the warrants that were issued, 60 of those 112 were just dismissed, null prost. 13 of those 112 were found not guilty, 4 were put on the STED docket, 3 were given PBJ, 1 was dismissed, and 21 are now active cases. That meant, you know, for us, we only found, if I'm not mistaken, 12 cases total out of 112 that were found guilty. And my fault, 10 guilty findings of the entire 112 were found guilty, and these were individuals that were issued warrants and were arrested. Out of the total 290 cases involving this, also including summonses, 165 of these cases that were issued by the commissioners were null prost. 49 were not guilty, 9 were STED, 4 for PBJ, 1 dismissed only to have 11 guilty. 11 cases were found guilty. That includes the 10 that were issued by warrant, meaning 1 out of 178 summons were found guilty. Those numbers are staggering. These numbers say we clearly have a problem, we clearly have an issue. One of the things in looking at the bill that we also concerned about came from the House side and said there was a 72-hour period for the state's attorney's office to do the investigation. We would ask that that 72-hour period be removed. We have consulted with the Attorney General with that OAG opinion, and you know they talked about that requirements. We have to have the separation of powers concept that's embodied in Article 8 of the Maryland Declaration of Rights, aside from specific powers of 3 branches of government. So we want to make sure that the judiciary can do what they need to do, and that the prosecutors, we can do it. We're going to try to, every prosecutor's office will try to have the investigation as quickly as possible, but we do know that if an individual has an issue and they are worried about their safety, we do feel that they have the opportunity, if they wish to take out a protective order or peace order. At that moment in time, our office will monitor that to make sure we try to be as quickly and as thorough as possible, because that victim would be there. Oftentimes, one of the issues we have is when they take out a summons with a commissioner, when it's time to talk to that victim, time to talk to that witness, they don't want to return our telephone call. So that individual sits in jail for 30 days before they're not guilty, and that spends money for the public defender's office, our office, and the system. Thank you. I ask for a favorable ruling.
Mr. Chair, members of the committee, my name is Brian Levy. I'm a supervising attorney at the Office of the Public Defender in Baltimore City. This is a bill where the Office of the Public Defender and the state's attorney's offices in this state agree. Because court commissioners lack the ability to investigate the allegations put before them, they act as a rubber stamp, issuing charges and under our current system, arrest warrants based on unverified, uninvestigated, and occasionally patently false allegations. This system invites abuse by those willing to utilize our criminal justice system to seek revenge and inflict harm on others. While prosecutors ultimately review, investigate, and determine whether to pursue charges issued by the commissioner, such review rarely occurs prior to the issuance of an arrest warrant. By then, it is too late. An arrest warrant alone will have devastating negative consequences on somebody's life. They may lose their job, their housing, face humiliation, and face trauma, both physical and emotional, due to being arrested, even when the cases are ultimately dismissed. Our current commissioner system is regularly abused, and I want to emphasize a particular place where it's regularly abused, that is by perpetrators of domestic violence, who often file false charges against their victims in order to retaliate and protect themselves from prosecution. When believing that they may be charged or facing the police being called, perpetrators of violence often go to our court commissioners and file false allegations to get their victims arrested. This bill will not affect the police's ability to make arrests or obtain warrants, but it will put a crucial investigative screening procedure in place before arrest warrants are filed, when they are filed by civilians, where civilians are filing uninvestigated, uncorroborated accusations. This bill will reduce the number of warrants being filed in false and frivolous cases, minimizing the great harm that is done to innocent people. I urge a favorable report.
Senator Folden, then Senator West.
The State's Attorney, if I could get you to come up to the mic.
Yes, sir. Yes, sir.
Hey, good to see you, sir.
Good to see you as well, Senator.
So I'm a little confused because I was all in when you were speaking, and then the public defender stood up. So I'm not sure what to make of this.
See, when both of us, that must mean it's the right thing to do.
I'm with you. I appreciate it. Thank you. Thank you for both of you.
Thank you.
Thank you, Mr. Chair. Mr. Bates,
yes,
I came in late to this hearing. I was over in the House. But the statistic you recited towards the end of your testimony was just stunning. So you're saying there were 178 instances when a citizen went to a commissioner and got an arrest warrant issued. And of those instances, 177 of them resulted in dismissal charges or no conviction. Only in one case of 178 was the arrest warrant found to be warranted?
That wasn't the arrest warrant, that was the summons. However, in the arrest warrant, there were 112, of which there were 10 guilties. And the numbers, by and large, they're staggering. And the main reason is we don't have time to do the investigation. When a person, and as you know, Mr. Levy has talked about, you have some of the perpetrators are out there not wanting to get justice, they're wanting to avoid prosecution. And then you may have a situation where you have an individual who takes out charges against a person who's been their abuser, and by the time it's getting ready to come to court, they may have now talked to them, realized, you know, have bills, I have other things, and they, in an unfortunately vicious cycle, then they step away. We want to be able to have that contact with that victim as quickly as possible, get them the services that they need, get them the support that they need, put together good cases. The other thing that this does, that's 290 something, that's 300 cases my office has to do, and oftentimes the public defender's office has to do. So those cases are being taken away from prosecutors and defense attorneys that need to focus on other things, but also the amount of work that the judges also have to do as well. We want to be able to focus on those violent offenders to make sure we protect the individuals who are victimized.
The second question is, I'm not familiar with this commissioner system. I'm familiar with the district court judges, the circuit court judges, the appellate judges. Frankly, I was simply unaware that we have these commissioners who have the ability to, currently have the ability to issue warrants for people's arrest with no judicial review whatsoever, and no review by the state's attorney's office either, correct?
Correct, and we're just trying to stop that. In this bill, they still be allowed to issue a summons, but we're saying that they hopefully will not be able to issue the warrant. And when I quoted you those figures, the warrants were the ones out of, I think it was 100 and 12 were issued warrants, of which 10 of those individuals are guilty. But 60 of them were not guilty. And so we really feel that the system will still be able to work more effectively, more efficiently, and we also believe we'll be able to protect more victims of domestic violence.
Thanks for your comments. I really appreciate it.
Thank you.
Senator Henson.
Mr. Chairman, for the state's attorney, I believe it was Mr. Libby, the public defender, that talked about some of the unintended consequences of it. But if I might ask you to give us a perspective on if a person is, he mentioned a domestic abuser might want to use this as an opportunity to have their victim arrested as well. As the state's attorney, could you talk us through what that might be like and talk us through the Fifth Amendment and how that would play out in a trial if a person is arrested and there are cross charges against two people, what that might look like and how that might complicate it?
Well, yeah, thank you, Madam Senator. A couple things. So oftentimes, sometimes it's a rush to see who's going to get to the courthouse first. And let's say that, you have A and B. A has basically assaulted B, the victim, made threats to the victim, and now the victim's upset, crying, and then grabs the phone to call the police. Then A runs away, goes to the courthouse, and then takes charges out to say B attacked them, assaulted them. Now the police take B down to the commissioner's office. Now B takes out charges. So now you have both of them having charges. Both of them will have the opportunity to be represented, and then both of them will go ahead and say, we're going to invoke our Fifth Amendment right, which means the state's attorney's office really can't talk to either the victim or the person who is the perpetrator, because now both of them technically are victims, so to speak, and then we don't know anything that's going on with the case. And because of that, and they invoke their Fifth Amendment right, meaning they have a right to remain silent, that therefore that case is null pros and dismissed against both those individuals. We're still in the same situation we were in before. It's almost even worse. And so what we want to be able to do is if a case like this comes into our office, we can now look to figure out more. We can also maybe talk to the officers who maybe had been at the scene to try to pull the body camera footage and things like that. Sometimes when the police take an individual down to the commissioner, they may not have the information or log in to show that they were the ones that went to the scene. We just know that there's a victim there who's taking charges out. And so it allows us to focus on the system in a way that we make sure it works as simple as possible, but to have prosecutors to know what we need to have to put together a case. We can sit down and say, this person wasn't a victim. We're not going to pursue your charges. However, B was the victim. We will be pursuing those charges. And now, because A spoke and they've written a statement, we could technically use A's statement against them. But we need to have that opportunity to be able to do that investigation.
Thank you. I appreciate it.
You're welcome.
If I may ask of Mr. Libby. Mr. Libby, would you help us understand some of the collateral effects that might happen in one of your clients' lives? Be it immigration consequences, violation of probation or parole, or what would that look like if a person were subject to an arrest warrant without some of the protections of this bill?
Certainly. So I'll give an example of a client I referenced in my written testimony. She was a victim long-term of abuse, and in an attempt to escape her abuser, she left him, rented her own apartment, didn't tell him where she was. And he filed criminal charges against her. She was arrested. She worked in the medical profession. Her job learned of those charges, so although released at her bail review, her job suspended her. She became unable to afford rent. She went back to live with her abuser. When I met her, she said, I'm not worried about this case. He's not coming to court. He never comes to court. This is the 4th or 5th time he's done this to me. It is a pattern we see again and again and again of individuals abusing the commissioner charging system to their advantage. And the cases ultimately, as the statistics show, get dropped, get dismissed, don't result in guilty findings. So an arrest is an arrest. It means the police are putting you in handcuffs, booking you, taking you down to a commissioner, and that commissioner is going to decide whether to hold you or not. And if you are held, you are seeing a district court judge for a bail review. And at that stage, the only information are those charges. That's what people are looking at. So if the accuser says, she chased me around the house with a brick and hit me, a judge may very well say, well, that's an allegation of violence. At this stage, we don't have any other facts. We haven't had a trial yet. I'm going to order that person held without bail. And 30 days go past before that individual gets their first trial date. A state's attorney gets to review the case, and they should be, and they are reviewing them earlier, but time is passing before justice is being done, and that person is being released to devastating consequences upon their lives.
Thank you. Are you able to give us any perspective on any collateral consequences as it relates to immigration?
Absolutely. So we are seeing this oftentimes when an individual is arrested. That arrest is going to trigger notification to immigration authorities. And so we are seeing individuals whose cases are quickly dismissed, who are being released at bail review, being apprehended by immigration officials because of false charges that are being placed against them and deported. And we have situations where individuals are reporting to us, this is being used specifically because they're aware of my immigration situation as a means to attempt to get an individual deported. That is something we have immigration attorneys at our office that have highlighted, that is regularly occurring, and is something we are always worried about, are federal immigration authorities going to be notified of an individual's whereabouts? And I'll tell you, and although I don't practice immigration law, the detention hearing for immigration purposes, an arrest, not a conviction, is going to be looked at as a discretionary factor. So somebody that is arrested on false charges may not be released pending their immigration hearings because of the accusations that may later be dismissed or result in a not guilty.
Thank you. Thank you, Mr. Chair.
All right, Senator James.
Thank you, Mr. Chairman. I have very much apologized that I was out of the room. So if these were asked and answered, and then we will I'll take it offline. But I also want to very much thank you, Mr. Bates, because when you are interested in a bill, you really, make it a point of reaching out to legislators. And I know you came up to my hometown when something was very important. And without your coming up to my hometown, I don't think I would have gotten the full import of the issue that we were dealing with at the time, and it left a big impression. Thank you for being here as well. I just wanted to highlight that. Just a couple of quick questions. Is this more prevalent in places like Baltimore City, as I have not heard about this in Harford County? So I'm just trying to understand if it's, and sometimes things become contagion. Somebody learns about something and then it becomes the MO or something. Is it more based in the urban areas or Baltimore City, if you know? And then I have a follow-up.
I don't know totally, but what I can say are two things. Number one, Maryland State's Attorneys Association, we support the bill as an association.
Okay.
What I can also say is that the numbers that I quoted you are the same, look very similar in Montgomery County. The state's attorney, John McCarthy, and I were both saying, I think 80% of his cases are dismissed on commissioners' arrest warrants and summonses. And that's pretty high. And so if you have Baltimore City, you have Montgomery County, I don't want to speak for Prince George's County, but I would probably guess that they're very similar from my days being a criminal defense attorney. And unfortunately, you have this type of abuse happening more often than regular. But what I can say is the MSA supports the bill.
Well, having done domestic work as a very minor but consistent part of my practice, I've seen the misuse of that area of the law. So it is not surprising to me, but I think the stakes are perhaps even higher when you're going out and arresting somebody, although allegations and using the judicial system in those heated domestic situations is a very sad thing that occurs. The second thing, again, if you address this, then you'll tell me later. There is a little bit of unfavorable testimony in here about particularly domestic violence. I think how I read the bill, you're still able to, court commissioner can still issue a summons, do other things, but do you want to say anything more, if you didn't already, about this worry of that immediacy of getting someone arrested and a vulnerable person?
No, without a doubt, it's something I also care greatly and deeply about. As prosecutors, our number one focus will always be victims. However, we also have to make sure we balance, and as Mr. Levy, my colleague, also stated, is that the victims are being victimized by the perpetrators and accusers by using this system. Right. So we say if you issue a summons That's one way to start the process. But also the victim of domestic violence can go and ask for a protective order, and then we kind of rings the doorbell so we can pay as much attention to, hopefully at that moment in time, when that case is there, our hope and goal within our office to make sure we have a prosecutor as close by as possible to speak with that victim as quickly as possible. So if they're hopefully even at the stage of having a protective order, and we speak to that victim, we have that information, then we can hopefully also try to help them get an issue, ask the court, because we won't do it. The court is the one who would issue the arrest warrant as quickly as possible. Right. But I do understand the apprehension without a doubt. But also, I think we gave some numbers, and our statistics are 290 cases are from the commissioner, and 11 were guilty. And so it's very problematic.
Well,
and so we felt it's a compromise.
Thank you for addressing it. Thank you.
Thank you.
Thank you. If you wouldn't mind, I have a question.
Yes, sir.
And kind of piggybacking on where you were just talking. So it's the Governor's Office of Crime Prevention and Policy and the Governor's Family Violence Council who have written the opposition. And they were talking, from what I could tell, it centers around the 72 hours. However, in your testimony earlier, you had mentioned something about the 72 hours. And when I'm looking at page 4, lines 7 through 11, I think that's in the bill where it talks about, or it states, on receipt of an application for a statement of charges under subsection A3 of this section, the state's attorney shall review the case as soon as practicable, but not later than 72 hours after receipt to determine whether to request that a judge of the district court or a judge of the circuit court issue an arrest warrant. In your testimony, you said something about amending or modifying the 72 hours. Would you mind walking me through that?
So we agreed with that. We're talking with the domestic violence DV community. However, when we spoke to the Attorney General's office, it's unconstitutional the way that's 72 hours. You cannot order prosecutors to do anything within a time period, and it's kind of discriminatory because what about the other cases and things like that? And so because of that, we couldn't legally do it. What we will do is, from our standpoint, we're going to have to pay closer attention. If the victim goes and looks at a protective order, my office needs to make sure we're there, we're understanding, we're monitoring that situation a lot more closely. That's something we can do internally. And we recognize the 72 hours is not a rule, is not legal. And so because of that, that's why we ask that it not be part of this bill.
Do you have an opinion on that from the Attorney General's office?
I do.
Would you mind sharing it?
I can quote you the case. It's Murphy versus Liberty Mutual Insurance, 476 Maryland 333-372. It's a 2022 case.
But if you have an opinion, would you mind sharing it?
I will definitely share it with you.
I appreciate that. And is there language that you now have? Because I'm assuming what we're talking about is amending that portion of the bill.
Yeah, I think the only language is that they would use, the state's attorney's office would use due diligence in their investigation. And that pretty much just says that we're going to try to investigate it as quickly as possible.
So you couldn't even say review the case as soon as practicable and just delete, but
as soon as practical, yes, and use their due diligence.
Okay. Seeing that there are no more questions, I believe we do have a few unfavorables.
Thank you. Might be excused.
All right, you're excused. Thank you. Judge Morrissey and Ms. Lennick.
Good afternoon, Chair Sidnor and members of the committee. On behalf of the judiciary, my name's John Morrissey. I'm the Chief Judge of the District Court of Maryland. The judiciary recognizes that there's a very real problem when non-law enforcement individuals perjure themselves when seeking to file charges. That's what we're here about. That's what House Bill 336 was designed to fix, but it doesn't do that. While I appreciate the efforts of the House Judiciary Committee, and in particular Delegate Phillips, who was here a moment ago, he really worked very hard on that, as did the entire committee. But it was moving super fast through that committee. In fact, we didn't receive the amendments until mid-hearing on Friday. Those amendments were completely scrapped, and amendments were made as it was going during the committee hearing on the day before crossover. there really hasn't been a meaningful opportunity for deliberation on what is a significant change to the system that's existed for 50 years. It's going to affect commissioners, judges, state's attorneys, public safety, victims, and defendants statewide. Provisions in the bill shift core judicial responsibility and authority from the district court commissioners to the state's attorneys, particularly around probable cause determinations, charging decisions, and whether to issue warrants or summonses. House Bill 336, as amended, blurs these boundaries in ways that jeopardize judicial independence and ignore public safety. There's a reason that the system was set up as it is with the commissioners, because they serve as neutral, unbiased, and independent resources. They're available 24 hours a day, 365 days a year for those victims that may be afraid to go to the police or face indifference when they do go to the police or the state's attorney. Under the amended bill, commissioners must forward applications with an already issued summons to the state's attorney who would. You heard Mr. Bates, the amendment says 72 days, but he wants it unlimited right now. So that summons could just sit out there forever without the state's attorneys ever acting on it. But there's an exigency to a lot of these cases that aren't going to be addressed. The summons may also have already been served by the time the state's attorney gets around to reviewing this. And now a motion comes over to the court, an arrest warrant is issued. The person may have already been served by the sheriffs. It's placing the sheriffs and whoever's serving this to do it again. It's duplicative. It places them in harm again. The proposed amendments risk inconsistent outcomes and delays, especially in time-sensitive situations. The judiciary is more than willing to work with the legislature, the state's attorneys, and anyone else. There are solutions that we can fix this problem. This just isn't it. But this bill, as it stands now, creates new administrative burdens. It creates new workflows. It requires coordination among multiple systems, adding cost and workload without any evidence that the changes will improve public safety or efficiency. In fact, I worry about the opposite. I'd be happy to talk to you at length about the commissioner system and the training that we do. I'd also, everyone says the commissioners are only college graduates. They go through extensive training. There's a 52-part core training that they go through that lasts months. They go to a commissioner academy that lasts a week. They have a staff member that's assigned to them until they're 3 months later able to go out on their own. 100% of their workload is examined by more senior commissioners. And if there is a problem, I personally get involved in it and will retrain if we need to or take other administrative action if it's necessary. It's not a matter of whether the commissioners are trained or not. It's people perpetrating fraud on the court. And that's what I'd urge this body to focus on, and I'd urge an unfavorable report as a result. This just isn't ready for prime time, quite frankly. I'd be happy to answer any questions, but I'll defer to Ms. Lenny.
Good afternoon, Mr. Chairman, members of the committee. My name is Dorothy Lenig. I'm the executive director at GOCAP. GOCAP was not going to originally get involved in this bill, but after thinking about this a lot, I realized I just need to publicly state that I don't think this bill is going to address the proponents' concerns, and I think it's going to jeopardize victim safety. The proponents want to stop people from maliciously filing complaints against innocent people. But to support that concern, they point to the number of citizen complaints that don't result in convictions. What they don't account for is how many times does the complainant just not come back to court because they're either afraid of the perpetrator, if it's a domestic violence case, they can't take off of work, they don't have child care, they don't have transportation, or maybe the state's attorney just couldn't get a conviction because there wasn't enough evidence. Before we dramatically change the role of the commissioner, I think we really need to determine how many of these complaints fall into each of these categories so that we can adjust each of those problems. If we don't, we're going to strip victims of this critical form of protection, which is going to further harm them. We're going to reduce victims' access to justice because we're going to reduce their access to the courts. And we're going to fail to correct the problem that we actually want to correct here. Judge Morrissey talked about the 72-hour issue. If we take that out, that means there's no time period, so then that summons or warrant would just sit forever. In addition,
we think about the state's attorney is going to have so much more evidence in front of them, but in fact, they're going to have less evidence in front of them because all they're going to have is a description of what the complainant said. They're not going to be able to see the demeanor of the witness. They're not going to be able to see the person in person. So they're actually going to have less evidence. And I just wanted to respond to something that the public defender was talking about, how this is going to really help domestic violence victims. The Maryland Network Against Domestic Violence opposes the bill. I think they have a better sense of what's important for victims. So we urge an unfavorable report, and I too am happy to answer questions.
Thank you very much. We're going to go Senator Charles, and Senator James, and Senator West.
This is for Judge Morrissey. Could you come up, sir? It's good to see you,
Senator.
How you been?
Good, thank you.
In your testimony, you stated something. You said you recognize there is a problem. That's correct, right? There is an issue.
It exists not just with the commissioner's system, but with interim and particularly temporary peace orders and protective orders, which are going to be seen by a judge, and it's happened to me personally.
Yep. So we know there's a problem. And you mentioned there are ways to fix the problem. Has your office done anything to fix the problem?
It's not my responsibility, Senator. It would be, there's a number of different ways. One, prior to coming to the commission, they could all go to the state's attorneys, right? Any civilian that wanted to file a complaint against an individual would have to go to the state's attorneys, and the state's attorneys could investigate, take as long as they want, and then make a recommendation to the court to file charges. They could go to the police and do the same thing, but frankly, unless the police, in my experience at least, unless the police witness the event, that would be an on-view arrest. They say go down to the commissioner and file charges. So you're taking that away from individuals if you change the way this is.
So you mentioned a way. What are some other ways to fix this problem that exists right now?
Prosecute perjury.
Prosecute perjury.
You know, they all say it's really hard to get a perjury conviction, but in my mind, it's like any other case. If the person, they are under oath, they're swearing out criminal charges against an individual, and if they lie, take the case and prove it to the court. We deal with that every day in court.
How often have you, as the chief judge for the district court, how many perjury cases have you actually seen come before?
Never.
And get a
zero.
Zero. Mm-hmm. And no prosecute. So zero came, zero prosecuted.
That's correct for me.
For you.
It's limited amount. I don't have the statistics in front of me, but it's a very rare prosecution.
Okay. Did you get with the sponsors at all to address some of these issues that you're bringing to us?
So like Ms. Lenning, I tried to stay away from this. I did not want to get involved in this. I fully respect the legislature's prerogative in changing the way things happen. But when the amendments this was last Friday, when the amendments got put in, it dramatically changed the bill. And those amendments were, in my opinion, so bad that I had to get involved with the bill. And they tried very hard to accommodate my concerns on it, but it was moving so quick. I mean, it literally was moving quick. Things were changing. There was 24 hours. I had to remind them the state's attorneys don't work on the weekends. Commissioners do. They're open 24/7. You know, that's one of the benefits of the commissioners. But I also heard, and I won't belabor this, but there was a lot of misstatements made in the House hearing about statistics and about my commissioners. And it's deeply troubling to me that people take these opportunities to say the commissioners are untrained. You know, state's attorneys might not like it when a commissioner makes an independent decision that they don't find probable cause on a police officer-generated complaint, or that they don't. I just had it recently where we were called to task because my commissioners did not, or it was my commissioners, did not issue a warrant on a particular offense. I wouldn't have issued the warrant. It's not a training issue. It's really, anyone can come into the court, and I've believed them. I've bought it hook, line, and sinker where people said they presented a very reasonable case. They showed me injuries, but yet they were the perpetrator, not the accuser.
All right. You had said another thing in terms of you typically don't get involved in a lot of these issues. Isn't it true that the courts have, the judges come together to address legislation and they send letters of support or letters to go against a lot of our legislation?
We do most of it. Part of the problem that I have right now is the operational way this works. It creates loops in the system, particularly if that 72 hours is removed. I mean, Mr. Bates and I have spoken extensively about this bill, and we've tried to figure out the way it can. It probably can be done. We just need to sit down in a room with with the Miss Lennings and the House of Ruth and the victims' advocates to sit down and go, what way can we reasonably figure out a process to try to limit the amount of fraud that's committed on us and yet respond to the emergency nature of some of these filings?
Well, the good part is we got about 14 more days left, and you guys can get with the sponsor and bring forth those recommendations that you guys typically do. Bring those recommendations and work with the sponsor on this bill.
A lot of people don't like my recommendations, Senator.
I know.
I don't know what that is
one
about.
Of them sometimes.
I don't know why that is, but it is. I think Ms. Lenning wanted.
I actually think that's something that we need to think about. It's not a 14-day process. I think this takes some really serious
Those 14
consideration.
days left in session.
Yeah, no, I know how long. Believe me, I have my countdown calendar, and so does my husband. We need to think about this much more carefully. We need to look at what other states are doing. Not only do we have to figure out how to get people to stop filing malicious charges, we have to figure out how to get people who are too scared or too unable to get back to court, if that's the appropriate thing.
Do you know what other states are doing already?
Well, I don't, but I'd be willing to convene a group of people. If somebody asked GOCAP to, we could, but get everybody there, not just the state's attorney and the smaller group they're working, but with everybody, the court commissioners, the other advocacy groups, bring everybody together. Let's look at what other states are doing. Let's look at what we can do to improve the system so that we can get people who need to be back in court, feeling safe about it, and the people who are maliciously doing it, really stopping and think before they do it. That's what I'd like to see happen, but I don't know what other states are doing, but somebody's probably doing something interesting with this.
Thank you.
All right, Senator James and Senator West.
Thank you. Following up on Senator Charles and just being a little more specific about this, I kind of remember, Judge, that with the court, we had bills about voir dire and things like that, and the court came in and said, look, we're really looking deeply. It may not have been, it was at the circuit level. And we were going back and forth about, should the legislators do this? Should the courts do it? So I appreciate your reluctance to start to weigh into our arena unless you're called upon. And I think what you're hearing is we're calling upon you now. We're asking you for your involvement. To me, it seems that if this is not the right bill, the right thing to do would be to absolutely codify a group in this bill to require that stakeholders that you've brought up and others hammer out a solution and report back to us if this is not the ideal set of circumstances. It sounds like you are amenable if you're asked and called upon to do that. Is that correct?
Absolutely.
Then I look at my gut and just my own, if you heard me, my own limited practice in domestic work, which was very limited, but unfortunately was consistent over the years that I kept doing some of it for a certain clientele. I mean, I saw in my own practice abuse of the judicial system in a different way, but just a lot of abuse. So I don't have any doubt that this system is not in fact subject to and experiences abuse. That's hard for courts and the judiciary to sort out, not to mention the harm is done when you begin to make the allegations, even if on the back end, a long time and a lot of damage later, you maybe sort things out. Now, the state's attorneys have provided data, and I don't know if you had a chance to look at it, and I don't really want to cross-examine you on it, but if this data is correct, it further exemplifies that there's a serious problem with the system as it exists, and particularly when it's a citizen complaint. But if I saw other data, and maybe you could provide it, where there's same kind of, disparity, if you will, between how the complaint comes in from a prosecutor or whatnot versus the citizen, and the result were that dramatically different, I might be less alarmed, but I probably suspect this data with that big disparity is probably accurate in this one area. Do you have a reason to think that the data is wildly inaccurate? I mean, don't you think this data is probably somewhat accurate about the big number of citizens complaint and not resulting in, an actual conviction? That differs from the other two ways.
Right, that's a great question, Senator, and it probably is. It's probably statistically higher for a civilian-generated complaint not making it to a guilty finding than it is for a police officer. Right. But the numbers, I've sat through dockets where a entire docket that was, or the very large majority of the docket that was police officer charged has been null prost. For whatever, there's a myriad of reasons why.
I get that. I don't want to just overplay the data, but I have a sneaking, my common sense tells me it's probably the biggest spread is in this particular avenue. So that would be indicative of an additional problem in addition to the global problems that present in all three, don't you think?
Anytime there's an ex parte communication with the court, you're always subject to getting one side of the story, right? And our whole legal system is based on an adversarial, two sides going at each other so you can weigh the evidence from either side. In a morning docket in domestic violence, when I was sitting in Prince George's County, I would hear a case, find the standard of that at that time was reasonable grounds to convince me that I should issue the temporary protective order, and then the other side comes in the afternoon, and I equally accept their argument. And then you're left scratching your head, who do I believe? And frankly, many times people exaggerate in court, or you're trying to establish what story is more likely than not in the situation that comes, and that really requires both parties. The problem is there's an exigency in these, there's a real problem. Right. Someone may die tomorrow if I don't act today. Right. And unfortunately, a byproduct of that is people can game the system. Yeah.
So, but my point is, I think we can do better. I think that we all know there's a tendency for exaggeration, and it bleeds good into perjury. I think it is more likely in a citizen-driven, for a variety of reasons. So my hope is that if we aren't able to do this bill, that we could meaningfully, in the days we have left, because I really with Senator Charles on this, there has to be a serious convening and a serious resolution that comes in a bill that next year or the year after, because I really don't think this can continue the way it's going to. And I think you'd be amenable to us proceeding in that fashion if we don't pass this bill.
As long as you make Ms. Lenning part of the committee, too.
I will make her part of it. All right, thank you.
Judge Morrissey, as I indicated earlier in my conversations, I think it was with Mr. Bates, I'm just totally unfamiliar with this commissioner system. Can you give us a little more information? Are the commissioners lawyers? Are they past the bar? Are they admitted to practice law?
No, they're not. They all have degrees from college. You'll bear with me a little bit. They're required at a minimum to hold a bachelor's degree from an accredited university. Upon hire, they receive a 1.5-day orientation at commissioner headquarters. They're then, within the first 3 months, have to complete 14 modules, 52 total lessons on what we call core competency for commissioners. It's actually, we have clerk competency, we have this whole core program throughout the judiciary. Those classes involve ethics and professionalism, screening, probable cause, charging and issuance, legal research, records checks, initial appearances, bails and bonds, bench warrants, civil orders, fugitives, circuit court process, and juvenile justice, and some other administrative type things. Biannually, any new commissioner has to attend a week-long training. So twice a year, we offer a new commissioner academy, we call it. That's a week long. It goes over, again, many of the issues that are involved in the competency, ADA, commissioner's manual, elements of crimes, probable cause, issuing charges, background checks, speaking to the record, initial appearance presentment, pretrial release determinations, restrictions on pretrial release, bench warrants and bail bonds, civil orders manual, domestic violence interactive activity where we role play with domestic violence. I don't know who taught me it, but I've been to that training myself. I thought it was a great idea. We incorporated it in the commissioners. They have quarterly meetings. Each district, we're divided into 12 districts. Each has an administrative commissioner. They conduct quarterly meetings where they go over trainings. We have an annual commissioner conference where every commissioner in the state comes in for a one-day training to implement new laws that have been legislated each year. We have an educational bulletin that we call 42G, which is the constitutional amendment that makes the commissioners, that publishes highlights and training tips for all the commissioners, and all the judges read it also. We have a library, a digital library that they can access at any time, and we have a standing committee that is comprised of judges. Judge Patty Mitchell, who some of you may know, who was a longtime judge for the district court, started out as a commissioner, and she chairs that committee and makes sure that the educational programming and training is appropriate for that. Well, just as one other side, Senator, and I'll stop talking, I promise. The concept that an individual that's been highly trained like that can't make a probable cause decision, I ask you, police officers make that. I wish Senator Follen was here because he'd back me up. Police officers make probable cause decisions every single day on the street, and they're not attorneys.
Okay, I hear all that, but now I'm looking at the statistics provided by State's Attorney Bates to us, that from the beginning of 2025 to now, so that's 12 months plus 3 more months in 2026, 15 months, there were 290 civilian complaints received by the court commissioner. I assume he means Baltimore City Court Commissioner, because he's the State's Attorney for Baltimore City. And he says, of these complaints, only 11 resulted in guilty verdicts. So you have 112 warrants, 178 summonses, and only 11 guilty verdicts. It sounds to me like there's a rampant problem
But here's the thing.
in the system.
But this is why I'm here, because I listened to the voting session in the House, and this is exactly what people were saying. Of that number, there's no distinction between the people who filed maliciously and people who were truly victimized who chose not to come back to court. And what we're saying is we're going to lump all those people into one category. So somebody could have been horribly beaten up in a domestic violence case. I had clients like this all the time at the House of Youth, and they were too scared to go back to the trial. And that number is being lumped into that there wasn't a guilty finding. And that's what we have to figure out how to separate out, because we want to go after the bad people who are filing malicious charges, and we want to protect the people who truly are victims and help them go through with their cases if they choose to.
Ms. Lenning, I totally agree with you, but any system in which 290 complaints are filed and non-lawyers are issuing warrants and summonses to a large percentage of these people, and we only have at the end of the day 11 guilty verdicts, suggests to me rampant incompetence or rampant lying or rampant something.
No, it's rampant fear and rampant, it's difficult to get back to court. So if somebody doesn't come back to court, it doesn't mean the court, like truly a crime was committed. You know, somebody got beaten up. They come to the commission, they've been beaten up. They're too scared to come back to court. So because they don't come back to court, they can't prosecute the case. They don't have a witness. That doesn't mean the commissioner made a decision. It doesn't mean the commissioner's system is bad. That's the piece. This is why I'm here, is to communicate that, is that we can't lump all those things together.
Here's my concern. You have somebody who genuinely is innocent, who's back at home with his family, and there's a bang at the door. He goes to the door, and he either gets handed a summons or he's arrested. There's a warrant for his arrest, and he's put in handcuffs and taken off, and it ruins his reputation. And at the end of the day, only 11 of these people end up being found guilty out of 290 complaints. There has to, I guess my bottom line is there has to be a better way.
But we don't know.
This is not the best way to do this. Don't you agree with that?
I believe that there's a problem that we can address. This is not going to solve that problem, because the man who testified last year on this bill in the Senate, when this bill was also introduced in the Senate, he told a whole long story that sounds very much like that. But the state still prosecuted him. They believed that he should be prosecuted. So there's no divine intervention on who's guilty and who's not. It has to play out in the system.
So here's my thought. We ought to remit this bill for summer study. But when it gets in summer study, I hope that the judiciary is willing to be part and parcel of the study and have some representative or plural representatives on the study committee to add their 2 cents worth and their valuable expertise. Judge Morrissey, would the judiciary be willing to help to man this study if we did it?
Absolutely, absolutely. Like I said, when the bill first came out, I was trying to stay neutral on it, but then when the amendments came in, I got involved, and I was offering myself and my director of commissioners, who's been serving in that role for 12 years, who's truly an expert on commissioner systems. We'd be happy to do it. Again, I have more ideas than what I've already said on how we can work that I think will hopefully, I mean, you know, the state's attorney has a different position in a different job than the court has as a different position in job, and there's tension in the public defenders too. But we've worked together before. I think I have a good relationship with the state's attorney prior to today. I'm pretty sure I did, but.
So here's the deal. I frequently tell myself there's nothing new under the sun. And as soon as I say that, I find something new under the sun. This is new under the sun as far as I'm concerned. I was unaware of the commissioner system. I was unaware of these statistics. This is a problem we need to fix. And if it means summer study with all hands on board to get it fixed, we should do it. Do you agree?
I do. And in years past, we have hosted this committee as well as the House Judiciary on a ride along to watch what the commissioners do, as well as bail reviews by the judges. And I know members, I don't know if actual members right now that are sitting on here have attended, but in the past we have done that. I'd be happy to do that again. If anyone wants to see the commissioner system, let me know.
Thank you so much.
Thank you.
If this were to be remitted, I'm going to go to Senator Sinner next, but if this were to be remitted to summer study, I mean, would you be willing to help us understand or develop a list of potential folks, work with us to decide who's going to be?
Absolutely. Again, I agree there's a problem. I'd like to fix that problem.
Excellent. Also, would love to take you up on that offer for a site visit maybe for,
Sure.
that'd be great. That'd be very good. Senator Sinner.
Thank you. Unlike Senator West, this system isn't completely unfamiliar to me. I've had a family member who was a district court commissioner. Yeah, but if you wouldn't mind, and I think you touched on this a little bit, the history of this system, and why was it set up like this here in Maryland?
So the main reason why it was set up so that people don't languish in jail over weekends. Right now, you know, there's a number of things that the commissioner does, not that many. They do interim peace and protective orders and ERPOs, extreme risk protective orders. So at 2 o'clock in the morning, you have access to the judiciary. They are judicial officers like I'm a judicial officer. Their jurisdiction is just very limited to these ideas. That's an exigent circumstance where if someone has guns and is having a mental health issue, I think we'd all agree we want someone to take action on that and try to do it. Maybe, as Ms. Lenning said, maybe they're afraid to go to the police, but we can do it civilly with an ERPO and just get the guns away and get the problem resolved for the time being and kind of hope we can get more resources to that individual in the future. They do application of charges by police. If they want to come in and charge someone, the commissioners will review those charges based on what the statutory requirements are for the crime and determine whether or not there's probable cause to believe that whatever the police officer described is a crime in the state of Maryland, and then they'll issue charges. They will again make the decision whether it's a summons or a arrest warrant based on a number of factors. It's statutory what they look at, but it's basically how serious is this case? What's the prior criminal record of the individual? But they can't, the weakness in the system is they can't investigate, right? They're not allowed to call other witnesses and it doesn't go to that because 2 o'clock in the morning, you know what I mean? Nobody's gonna be up and answer a call or anything. Where the state's attorneys, the state's attorneys do have that capability, and that's where they need to come in. They do need to come in this, whatever solution it is to this, in my opinion.
It's about the four corners of whatever documentation is put forth. Just out of curiosity, is Maryland very different from other states? I mean, do other states have this type of system, or if they don't, how do they address that history that is being addressed by our court commissioner system?
So it is, there aren't many, I think there's a handful of states that have a quote-unquote commissioner system across the United States, but there's actually only 6 states that have a system like the district court that's a unified statewide court system as their lower level of court. But they have other, and what the district court was designed to replace was hodgepodge courts like municipal courts and justices of the peace. We rolled them all into one and created the district court in 1971. And I think that was a brilliant move by the legislature. It was voted, approved by a referendum to the voters. And it really provides at least an attempt to make statewide consistency through all of our policies throughout the state. They do have, I saw a person that does the same role as the commissioners. I think they called it a magistrate in one state. He would do them from his car. I saw him do them from his car on the phone. We don't do that. I mean, we do it in offices where people can come in and we can see the individuals. You know, they are making the commissioners are making judgment calls based on the person that's before them.
Thank you very much.
Thank you, Senator.
Thank you, Mr. Chair. And thank you to Senator West. I know he recommended a possible summer study. I know for me, I feel like we can address this stuff now. We shouldn't have to wait until the summer. You know, that means we wait till the summer. We got to wait till next year when more and more people deal with the same issue. Somebody sitting at home, like you said, Senator West, eating dinner with their family and randomly get a knock at the door and get arrested. We sit down and do work groups on bills all the time in this committee. I don't know what will hold us up from you guys getting the information that you need, sit down with the people that have brought the bill to the table, and let's address it so we can do it now. We keep waiting and kicking the bucket down the road. We're never going to fix this problem. So why not fix it now? What's your hesitation to fixing it now?
I'm prepared to offer whatever I can now. I think there's some structures that are going to be in place. I think part of the reason why, and I don't want to speak for the state's attorneys, but they're not a 24/7 operation, and you really need to be on this. So, I mean, part of it, again, is the urgency of the situation. There needs to be an immediate investigation of these things, and the state can have the authority then, if they don't believe the charges are worthwhile, null the case, null process the case right then and be done with it. It'll save us all time and effort, and it's those kind of ideas. But I don't know, I know Mr. Bates probably in the city is structurally prepared to handle that, but I worry about, you know, Hagerstown or Garrett, Oakland and Garrett County, whether, you know, the 1 or 2 state's attorneys that are going to be there are going to be able to handle the volume. I just don't know. I mean, I've never looked into it. There's also some of the data I don't readily have at my disposal right now. We never distinguished between we kept stats on how many warrants we were issuing. We just never distinguished between whether they were officer-generated warrants or civilian-generated warrants. We can do that, but I need to make programming changes to the computer and change forms and then train to do it. It's going to take some time. We've manually did 1 year worth of review, but it took an incredible amount of time of my entire commissioner staff to do it because the numbers are high. There were 24,686 charges that were filed, whether it's officer filed or civilian generated, across the state for calendar year 2025. We were able to subtract, so we know how many non-police applications there were. There were 17,599. I'm sorry, I didn't add the numbers up. There's about 100,000 charges that were filed. 17,599 of them were accepted charges from civilians. But remember, civilians can be Walmart security guards shoplifting. They can be fire marshals. So that definition of a non-police officer or state's attorney is going to group in a whole group of people that you may not want to be included in this, because then the inherent problem with a summons is that if someone ignores the summons, what do we do then? And go back to the stats. Out of those 17,599 accepted charges, there were 3,588 warrants were issued. So significant, it's about 20%. Now, normally what happens right now is if it's a summons that goes and it's served and the person doesn't respond, an arrest warrant issues for them, right? Because they now are ignoring the summons, and how are we going to get them to court if they ignore the summons? So we issue an arrest warrant. So that happened about 1,404 times because a lot of people ignore summonses. It's just the nature of how it works. So that accounts to be about 20%, a little bit more than 20% were warrants issued on civilian-related things. I heard some wild stories over on the House. Some people opined that it was as high as 50%, and it's just simply not.
Okay.
But I really do need a program. I know you guys want that data. We're going to do it whether the bill passes or not. I need to know the data too.
Yep. Also, this is a really complicated issue that people have been struggling with for a long time. It's not a 14-day, we're going to figure it out, especially at this point during the session. But I do think there are some interesting ideas that people have had. You know, one idea that somebody had was, what if we had one state's attorney, a centralized system that people could call into on nights and weekends? I don't know if we can set that up. I don't know if that makes sense. I don't know how many there are. We can't figure all that out in 14 days. But if everybody's committed to coming together to look at it, we can really open up the whole thing and try to address the actual problems, not just try to quickly cobble something together that's not going to fix it anyway. You're still going to have all these true victims who aren't going to come back, and the numbers are still going to be high on that side.
All right, we're going to move this along. Senator Charles, you have another line of question? All right, Senator Sidner, go ahead.
I was on notice that we have a victims commissioner here, as well as a district court commissioner. I don't know if, they might be able to provide some insight on this problem.
So we had this set up for two. I came in a little later because I was across the street, but we have two and two witnesses. So they want to opine offline. That'd be great, but I don't want to turn to like the fuller hearing that we already have. But happy to receive that testimony. But we've got a couple other bills. But go ahead.
Thank you. And we certainly have. We have the bill sponsor here. I'm just curious. Is she all right with a summer study? Or will we have the time to hammer this out in the time that we have?
So we have been dealing with this bill for 3 years. And I don't think that a summer study, because the judge and this young lady knew about the bill that we had. And so we did a lot of work with this bill, and the chair of the committee, he did a lot of work on this, and we all came together, and this is what we did. And we offered up amendments for domestic violence, and we sent out, we had testimony, we had commissioners to come in, we had the state's attorneys to come in, we had everyone that you could possibly think of to come in on this bill. And up until today, I have not seen her until Friday that she called us. And so they had plenty of time for us to get this bill right. And within 14 days, and for it to be a summer study, we'll have more victims that will be arrested. We have a young man that's sitting right here his mother who almost lost her house because of a false statement that he has not done. We had so many victims. Everybody is a victim. We have a commissioner who testified. We actually had 2 commissioners that testified on this bill, and we not one time have we seen Ms. Lennox from GOCAP until today. And so I don't think that a summer study will help. I think that we need to fix this now before session is over.
Are you saying that the commissioners that testified over in the House, they testified in favor of the legislation that was introduced?
Yes. We had 5 lawyers the first year. We had State's Attorney Bates, we had Schillenberger, we had now.
But outside of them, I'm just curious, what was their testimony? If you wouldn't mind just sharing.
We had one. I'm sorry. Okay, let me just say, they voted favorable because they said that the commissioner, she was a lifeguard. One of them was a lifeguard. They said that they didn't have to have this. What is it? Yeah, they didn't have to have this training. All they had to do was have a high school diploma. Now we're hearing that they had to have college, and they go through all of these trainings. So they did not say that they had to have those trainings done. We're just hearing about all the trainings today.
Thank you.
You're welcome.
Excellent. Further questions for the panel or the delegate? All right, thank you all very much. Thank you. So I saw Delegate Erickson was here first, and then Delegate Phillips, so come on up. House Bill 1467.
Yes, thank you so much, my friends of JPR. A lot of faces I recognize from the other side. Delegate Lauren Arkin here on behalf of HB 1467. You guys have seen this before. It passed in a bipartisan and unanimous fashion last year, but I believe y'all just had a lot on your plate last year. It's a small bill. It fixes a very specific issue that happened in my county, but also is probably happening in other counties. Essentially what this bill does is for fourth-degree sex offense, it allows for the introduction during sentencing of a repeated actor, so someone who has done this more than once, but outside of the state of Maryland. So currently, if you're in the state of Maryland and you've repeatedly committed fourth-degree sex offenses, when you're sentenced, they would be able to present that evidence. They would know that. But right now, if you've done the same offense outside of the state of Maryland, that evidence is not introduced. And so we did have a case in my county where we had a serial offender from outside the state that came in and offended, and we were not able to let the judge know during sentencing that it was a repeated pattern for this person. So small bill, again, bipartisan sponsorship, and passed unanimously 2 years in a row. Happen to answer any questions if you have them.
Excellent. Thank you very much, Delegate. Questions for the sponsor of the bill?
Okay.
Right. Awesome.
Thank you all. Thanks for your hard work.
All right. Have a good one.
You too.
All right. Delegate Phillips, welcome back to JPR. House Bill 1054.
It's always good to be back in front of our sister committee. Mr. Chair, I've asked, if you don't mind, I've asked the state's attorney to join us. This is a bill that, after a number of discussions with State's Attorney Bates, we've crafted to make a narrow but important change to Maryland law by extending the statute of limitations for certain misconduct by public officials 2 years, from 2 years to 3 years. Specifically, the bill applies to the prosecution of ethics violations under the Maryland Public Ethics Law and criminal malfeasance, misfeasance, and nonfeasance in office committed by public officers, including officers of the state, state agencies, political subdivisions, and bi-county or multi-county agencies. Under current Maryland law, most misdemeanors must be prosecuted within 1 year of the offense. However, because of the seriousness of misconduct in public office, the law already provides for an extended period of 2 years. House Bill 1054 simply increases that existing 2-year window to 3 years. The bill does not create any new crimes, and it does not expand criminal liability. It only provides investigators and prosecutors with an additional year to bring a case when misconduct by a public official is discovered. Cases involving misconduct in office are often complex and difficult to uncover. They frequently involve internal investigations, audits, document review, and coordination between agencies. In many situations, the conduct is not discovered immediately. It may surface through an internal audit, a whistleblower complaint, or a later review of government activity. When that happens, close to the end of the current 2-year period, prosecutors may not have sufficient time to fully investigate and responsibly bring a case. Extending the statute of limitations to 3 years that ensures that serious misconduct by public officials can be properly investigated and, when appropriate, prosecuted. The fiscal note indicates that this change is not subject to have any material impact on state or local finances. House Bill 1054 is a modest and practical accountability measure. It recognizes that misconduct in public office can take time to uncover and ensures that prosecutors have a reasonable opportunity to pursue cases that protect the integrity of government. And for those reasons, I respectfully ask for a favorable report on House Bill 1054. If I could say one other thing. The primary reason that this was brought was really, if you think about what is happening, particularly in law enforcement, if individuals are going through an internal investigation, by the time that is done, often we're 2 years in, and now a prosecution cannot be maintained, right? So we're really talking about kind of a unique scenario. And hopefully, the state's attorney, if you don't mind, if you could say a few words.
Yes. Thank you. Chairman Smith, just want to thank you very much, and all the members of the committee give me the opportunity to speak again. Once again, I'm Ivan Bates, State's Attorney of Baltimore City. And as Delegate Phillips talked about, the current statute of limitations is 2 years in investigating misconduct. We really would like to have it extended 3 years. Prosecutors who handle misconduct in office, investigation, and prosecutions against police officers often learn of alleged misconduct long after the incident occurred. Unlike more common crimes such as murder, theft, or drunk driving, wherein the offense is usually discovered nearly contemporaneously with the committing of the crime itself, misconduct is rarely discovered the time that it occurs, or at least it isn't discovered immediately by those who are responsible for investigating it of or possible prosecution of the misconduct. Let me give you an example. My office just yesterday charged 4 officers. We couldn't even get to that point until we looked at the body camera footage, but it had to go through 3, 4, 5 different layers before it got to our office. And the case was back in 2024, and we were really pressed to try to make sure we could charge those officers. Misconduct in office investigations generally start in 2 ways. The citizen's designee of the citizen attorney or the family member reports misconduct to the police department or the law enforcement agency to the state's attorney's office or attorney general's office. Or 2, the respective police department identifies misconduct itself through its own auditing process, triggering an internal investigation, potentially a referral to the local state's attorney's office. They have to go through PIB, they have to go through ID, they have to go through so many different layers, sometime before their cases even get to ours. My team and I have found a significant number of allegations of misconduct lodged against police officers come to our attention near the time period for the expiration of the statute of limitations. In cases citizens or designees reporting misconduct, some citizens who wish to file complaints are unaware of how to do so and are afraid to do so. And sometimes they're incarcerated, unable to do so, oftentimes months until they're released, and sometimes maybe a year or so after the release. In case where law enforcement agencies discover possible misconduct by their own officers, while complaints are frequently made by first-level supervisors who conduct immediate frequent audits of the subordinates, several instances of misconduct are often unearthed are not unearthed until upper-level commanders conduct random, sometimes mass audits. I think it's very important to understand for us and our focus is on really the police department, what's going on with the police, and that's really what we're focused on. And once again, we have a pretty robust practice in terms of trying to hold the police accountable in Baltimore City. And to be honest, just this past month and a half, we've charged 8 officers. But we had to do deep, thorough investigations. We had potentially 13 that came across my desk, and we were still pressed against the time clock to really do the investigation. We want to do the investigation right. We want to hold the officers accountable, but we also sometimes need a little more time to make sure that it's done the proper and right way. And that's why we're asking for a favorable ruling on this with the statute of limitations extended to 1 additional year.
Thank you very much. Senator has a question.
Thank you, Mr. Chairman. My question is for the bill sponsor.
Yes.
Thank you for bringing the bill. I've heard a lot of focus of the testimony is on police officers and the ability to prosecute those cases. But the scope of the bill, it's not limited to just law enforcement officers. It's everybody that's subject to the public ethics laws. Am I reading that right?
That's correct, and I think that's because of where it fit in the code.
Okay, so that would be members of the General Assembly, the governor, lieutenant governor, secretaries and heads of state departments, members of state boards and commissions, and really anybody that's exercising state authority would be subject to the additional 1-year limitation period?
That is correct. That is correct. But I would tell you, really the focus was on law enforcement, and I would be open to amending the bill to focus on what the real clear intent was. The challenge is, once again, the investigatory process, particularly with police, can be long, and it presents a problem for those who may want to bring an action, as the state's attorney mentioned. I'm not sure that the same thing applies to all public officials, but that is one, because we've created a process of internal investigation, PAB, et cetera, that really presents a challenge with with getting those cases heard, preparing those cases within a 2-year period.
I appreciate that, and I think that's important because we haven't heard any testimony about any challenges with any of the other categories that would be subject to the bill. I know in Anne Arundel County, we had an officer that their responsibility was to investigate sexual assault cases, and they routinely were not investigating them. They would make initial contacts with the victims, and then they would not investigate them. And when their commanding officers figured it out, the only thing that they could charge them with was this sort of malfeasance, nonfeasance sort of offense. So sometimes when it's that, I call it a catch-all, when it's the more so catch-all offense, sometimes that evidence, you find it later on.
Right.
Because it's not the sort of thing where it happens in an instant. And so you know immediately if it's an assault or if it's something different.
Right.
But that sort of malfeasance, sometimes it happens, it builds, and so additional time might have value. But when I looked at the other areas of people who would be subject to the bill, I had some pause about it because I know that when I Googled who has been prosecuted under these sorts of things, and I looked at people who were state officials that had been prosecuted, and I just noticed some characteristics about them, 9 times out of 10, they were Black officials. And I know, just based on what I know about people and human behavior, that's not always true, but the behavior that happens, it is just more often true about who gets called out for that behavior, who gets held accountable for that behavior, who is reported in the media about that behavior. And so I just had concern about if the bill were going to open an additional limitation period, that we were doing that in consideration of other things that we need to do to make sure that we're cleaning up some of those disparities. So I appreciate your clarity with us on what your intent is for the bill and the testimony for the hearing bearing that out.
Clearly, that was, and you know what? One of the things that I heard very early on in my first year is to do your best to think about the unintended consequences. So I thank you for raising that, Senator. And once again, I am more amenable to any type of amendment that this committee would like to make before sending it back to us.
I appreciate it. Thank you, Mr. Chair.
Thank you very much. Actually, I have 2 questions. One's for the sponsor, then one's for the state's attorney. And one, I'll just follow up with Senator Henson. We've had an iteration of this bill here before a couple of years ago. And one of the things or elements of unintended consequences that came up was that, for instance, that this could be weaponized and saved and then used during like an election cycle, right? So I personally, when applied equitably across the board, I actually don't have an allergy to extending the statute of limitations for misconduct in office, because I think that's a particularly offensive conduct, and it does real detriment to the public's faith in institutions and the hard work that we all do. And so I have a particular allergy to that type of offense. So actually, I'm not even, I'm not allergic to that. But one member used to bring up the fact that this could potentially be weaponized or misapplied, as the senator brought up. And so I wanted more of your kind of thinking on that. And then the second piece is for the state's attorney. How does this work just functionally? I thought, I thought the Office of State Prosecutor, do you guys have like concurrent jurisdiction? So like if the Office of State Prosecutor does these investigations or has this for political corruption, and then like wherever the jurisdiction that the activity happened in, then the state's attorney has, do you guys have like concurrent jurisdiction over that, or how does that, I actually just don't even know how that functionally works. But.
So first, let me answer your first question, Mr. Chair. I think that was part of the dialogue between myself and Senator Henson, right? And I do think that unintended consequence, we need to address it. I would love for you to address that so that it is really focused on what the intent was, and that was to deal with law enforcement, just so you know.
Yes, pretty much every jurisdiction, I know, especially in Baltimore City, we're the ones who investigate the police officer for misconduct. I'm gonna give you an example. We recently, and this has been in the paper, we recently charged police officer with misconduct, and a lot of it has to do oftentimes looking at body-worn camera footage. Body-worn camera footage, by the time we got it, it had been out there for a while. Once we receive it, we then need to find the victim, try to talk to the victim, interview the victim, try to talk to the other officers, understand what happened. Then we have to go back and understand the training. Then we have to also understand what's going on in PIB. Then we have to understand all of those things. And so the problem is that we, in my office, I think we have 6 attorneys that prosecute in terms of the police department. We pretty much look at every single issue except homicide. You know, that's the Attorney General's office. However, all the other issues involving police, the misconduct, the abuse, we prosecuted 4 officers, I think about a month ago, for financial. They allegedly were stealing overtime. And so these are all the things, but how do you find out sometimes they're stealing overtime? By the time it comes to our attention, by the time we get to the bank records and subpoena them, then we're right up there sometime at the statute of limitations. And so we want to make sure that we have the opportunity, because just because an officer may look like they've done something, then if it looks like it's egregious, then we may need to talk to an expert. By the time we talk to an expert, the expert may say, hey, based on the training and the way they were trained, they actually did things the proper way. But maybe we need a little more time. And so we're constantly running up against the clock. And when you run up against the clock, you're like, do you charge, do you not charge? Because when you charge an officer, you effectively, for the most part, ended their career. So we really take that very seriously. And that's why from our police integrity unit, this is a very important bill.
No, I appreciate that. Thank you. Further questions from the committee? All right, excellent. Hey, we'll get some amendments with you, the sponsor. We'll work together and move forward. But before you leave, I wanted to publicly say, listen, I know it's interesting. We've had bills in which the state's attorneys have been opposed to things, and bills in which we've worked together with the state's attorneys and public defenders and all that stuff. I thought today was a really good example in both judiciary and JPR for just people working together across and still remaining civil. So in particular for the state's attorney, I want to say thank you for your work in the city and down here in your advocacy and in your new role. So I much respect and high regard. I know we've had disagreements on policy, but it's been a real pleasure. No, I'm serious. It's been great, and it's been good. So just much respect.
I know we don't always
that.
agree, but I also know that everybody in this room wants the best for it.
That's exactly right. And
I appreciate the work that everybody does down
yeah,
here.
I just wanted to say that publicly because I think.
Thank you.
Yeah,
Thank you very much to everybody. Thank you.
All right. Hey, thanks a lot.
Well.
Appreciate it. All right, with that, that'll conclude the hearing for House Bill 1054. We have some delegation bills here. Is anyone here from the Baltimore County delegation for House Bill 305 rather?
We had a hearing yesterday. There's no letter, so we haven't acted on it. Chris hates it. Say that.
All right. So we'll hold off on that then since the delegation just met on it yesterday. All right, that's Baltimore. Is that it?
No.
Prince George's.
House Bill 1222.
Is here to speak against.
Against that bill? Oh, well, the bill's not before us, but we appreciate your time. We say.
Run it over here in 5 seconds.
We don't have a delegation letter, so we're not going to hear. And they just heard the bill, so we don't have.
I move unfavorable then.
All right, I registered. There you go. All right. All right. So Howard County delegation. We already did that one.
House Bill 1222.
What about 1222?
That's in your charge.
All right. Let's rock and roll. House Bill 1222.
All righty, everybody. For the record, I'm Senator Nick Charles, representing Legislative District 25, here in support of House Bill 1222. I'm also here in my capacity as Vice Chair of the Prince George's County Senate delegation. This is a delegation bill. The delegation has reviewed this legislation. We have a letter of support from the delegation. All this bill typically does is it's increasing the state's attorney's salary, which is currently $199,000, to put it on par with our neighboring jurisdictions. Montgomery County is paying their state's attorney $251,000. Baltimore City is paying $238,000. I wish the state's attorney would have stuck around so I could let him know. $238K. Anne Arundel County, $222,000. And at the same time, Prince George's County often carries one of the highest caseloads. And so because they carry one of the highest caseloads and are not being compensated fairly, we're looking to increase that as a Prince George's delegation priority. And so as highlighted in our county exec letter that you'll probably see in the package, the role is one of the most demanding in local government. And the bill does not create something new. It just corrects a gap that ensures Prince George's County remains competitive in recruiting and retaining strong legal leadership. Ask for a favorable report.
I didn't realize it was thunderstorming outside. Because he's making it rain. Oh, all right. That's terrible, terrible. All right. With that, he's not even laughing. He's not even laughing. All right. Appreciate it. Thank you very much. All right.
Nick, I appreciate you walking in with UMBC basketball team day.
That was really cool. All right, with that, that'll be the end for House Bill 1222. All right.
Listen, man, have you seen Muggsy Bogues?